Lady Gaga has just won a major trademark case over the word mayhem. And what makes this case particularly interesting is that the company suing her didn't just claim that it had been using the name for decades. It actually had a registered US trademark for mayhem covering clothing. Lady Gaga was also selling clothing carrying the mayhem name. So you might think that this would be a relatively straightforward trademark infringement case. It wasn't, of course not. And the company suing Gaga originally sought at least $100 million in damages. So what actually happened and how did Lady Gaga end up winning? Well, the company behind the claim is Lost International, which is associated with the Lost Surfboards brand in California. Lost has been around since the 1980s, and one of its founders is Matt Biolos, who is also known by the nickname Mayhem. The company says that it has been using Mayhem since the late 1980s in connection with its surf business, including surfboards, clothing, accessories, and other products. And importantly, Lost had actually registered Mayhem as a US trademark in relation to clothing. That registration covered things like t-shirts, tank tops, jackets, shorts, trousers, caps, beanies and sandals, so a whole variety of things. So this wasn't simply a case of somebody seeing that Lady Gaga had called an album Mayhem and deciding that they owned the word to everything. There was a genuine existing brand with a long history and registered trademark rights. Then Lady Gaga came along. She had started working on what eventually became her 7th solo studio album back in 2023. That album was ultimately called Mayhem and was released in March 2025. It became the name of the whole project. There was the Mayhem album, the Mayhem ball tour, and inevitably a huge amount of merchandise connected with Mayhem. And that's where things became particularly interesting, because Lady Gaga wasn't simply using Mayhem as the title of a piece of music she was releasing. She was selling t-shirts, hoodies, and other merchandise carrying the word Mayhem. In other words, she was using the same word that Lost had registered as a trademark in relation to the very thing that Lost's registration covered: clothing. And Lost argued that there was also another problem here. It said that the way Lady Gaga was presenting the word mayhem visually was extremely similar to branding Lost had already been using. If you look at the two versions side by side, you can understand why Lost wasn't entirely delighted. They're both stylized versions of the word mayhem with quite an aggressive, chaotic looking design. Lost therefore argued that consumers could believe there was some sort of relationship, association or endorsement between its business and Lady Gaga's products. In March 2025, Lost sued Lady Gaga in the federal court in California, and it was not a small claim. It brought a number of claims under US federal and Californian law, including trademark infringement and false designation of origin. And in its original lawsuit, Lost sought damages of at least $100 million, as well as Gaga's profits connected with the alleged infringement and various other remedies as part of the claim. It also wanted to stop her continuing to use the branding going forward. There was also another interesting commercial argument behind Lost's position. Lost is very much a surf and counterculture brand. Its founder's concern wasn't necessarily just that somebody would walk into a shop intending to buy a Lost t-shirt and accidentally buy a Lady Gaga t-shirt instead. There was also a real concern about what happens to the identity of a relatively niche brand when one of the biggest musicians in the world suddenly starts putting the same name onto merchandise that's being worn by millions of mainstream consumers. It's a bit different. From Lost's perspective, it had spent decades building an identity around this very niche brand Mayhem. Then Lady Gaga potentially had the power to completely overwhelm that identity almost overnight. So commercially, you can understand why they wanted to protect it. Lady Gaga's lawyers, however, were having none of it and had a fundamentally different argument. They said that Mayhem wasn't being used as the name of some new standalone clothing company, it was the title of an artistic work. Mayhem was Lady Gaga's album. The tour was the Mayhem Ball, and the merchandise was connected with and promoting that artistic project. They also argued that nobody realistically looking at Lady Gaga merchandise was going to believe that it had been produced by a Californian surf company. The merchandise was being sold through Gaga's own channels and at her concerts. Much of it was associated with her name, her image, and the wider album and tour. And that's where this case gets into a particularly interesting area of US trademark law. So normally, one of the fundamental questions in a trademark infringement case is whether consumers are likely to be confused. But the United States also has very strong constitutional protection for freedom of expression under the First Amendment. And when somebody uses a trademark as part of an expressive or artistic work, the courts can apply a special test designed to balance trademark rights against freedom of expression. It's known as the Rogers test after an early case called Rogers versus Grimaldi. Very broadly, the court looks at whether the use of the trademark has some artistic relevance to the work, and then it considers whether the use is explicitly misleading as to the source or content of that work. The first part wasn't particularly difficult for Lady Gaga. Calling an album Mayhem obviously had artistic relevance to an album called Mayhem. The much more important question was whether her use of Mayhem was explicitly misleading. And that is a much higher hurdle than simply saying that somebody somewhere might potentially be confused. Lost needed to establish something much closer to Lady Gaga explicitly representing that Lost was somehow connected with, endorsing, or responsible for the project. And there wasn't really anything like that. There wasn't, for example, a statement saying that this was an official Lady Gaga and Lost Surfboards collaboration. Gaga was simply using Mayhem as the name of her artistic project. But Lost had what I think is a pretty intuitive response to that. It effectively said, fine, perhaps the album itself is protected artistic expression, but we here are talking about clothing. A hoodie is not an album. A t-shirt is not a song. You're taking the word we've registered for clothing and putting it on clothing and selling that clothing commercially. And that is the part of this case that I find particularly interesting and particularly fascinating, because the court didn't ultimately draw that distinction. US case law recognises that protection for an expressive work can extend beyond the work itself to things associated with its advertising, its promotion, and its merchandise. So the fact that Gaga was making money selling Mayhem merchandise didn't automatically mean that the merchandise stopped being connected with the underlying artistic expression. That became extremely important when Lost tried to get a preliminary injunction. Essentially, Lost wanted the court to stop Gaga from using Mayhem on the relevant merchandise while the litigation continued. And obviously by that point, the commercial stakes were enormous. Gaga had an album, a global tour, marketing campaigns, and huge amounts of merchandise all built around the word Mayhem. Stopping that halfway through the project could have caused enormous disruption and cost. But in December 2025, the judge refused to grant Lost the injunction. The court accepted that Gaga's use of Mayhem was artistically relevant. And crucially, it wasn't persuaded that her use was explicitly misleading. Lost was essentially pointing towards the possibility of consumer confusion. But under this particular legal test, that just wasn't enough. There needed to be something more explicit indicating that Lost was actually behind or associated with Lady Gaga's work. Simply using the word Mayhem, even on merchandise, didn't establish that. But Lost didn't give up. It continued with the litigation and it amended its case. Eventually, it filed a second amended complaint, so it had further opportunities to try to address the problems that the judge had identified. And that brings us up to what has happened now. On the 18th of August 2026, the judge granted Lady Gaga's application to dismiss the case. Again, the crucial issue was that Lost hadn't sufficiently shown that Gaga's use of Mayhem was explicitly misleading. The court was not persuaded by allegations that Lady Gaga intended to cause confusion. There still wasn't an overt statement or representation from Lady Gaga at all suggesting that Lost was the source of or affiliated with the Mayhem project. And this time, the decision was particularly significant because the judge dismissed the case with prejudice and without permission to amend it again. In other words, Lost had already been given opportunities to try to fix its case. The court had already explained the problems with its arguments when dealing with the preliminary injunction, and the judge ultimately concluded that allowing another attempt at rewriting the claim would be futile. So at least at this level of the US court system, Lady Gaga has won. Loss has indicated that it intends to appeal, so we may not have heard the absolute end of this story. But I think this case illustrates something really important for business owners everywhere. There are two opposite mistakes I regularly see founders making when it comes to trademarks and brand protection. The first is, I've registered the trademark, therefore I own this word. You don't. A registered trademark can give you extremely valuable rights, but it doesn't normally give you ownership of a word in every conceivable context and the ability to prevent anybody else in the world from ever using it again. The scope of your protection depends on what you've registered, the goods and services involved, how the other person is using the mark, where they're using it, and a whole range of other legal considerations. And this case is a particularly dramatic example. Lost wasn't coming into court empty-handed. It had been using Mayhem for decades. It had a registered Mayhem trademark. Its registration covered clothing. Lady Gaga then sold clothing carrying the word Mayhem, and Lost still wasn't able to establish the infringement claim. But founders shouldn't take the opposite lesson from this and think, well, trademarks obviously aren't worth very much then. Absolutely not. A registered trademark can become one of the most valuable pieces of intellectual property a growing business owns. The second mistake I see is founders believing that because they've registered their company name at Companies House, bought the domain, and secured the Instagram handle, they've somehow protected the brand. Those are completely different things. Imagine you've come up with a brilliant name for a new business. You register the company. You buy the domain name. You do all the things you're meant to do. You pay an agency thousands of pounds to create the brand. You build a website. You print packaging for your branding. You start advertising the business. You accumulate thousands of customers. You build social media accounts. You start hiring. Maybe eventually you bring in investment, and 2 or 3 years later, a solicitor's letter arrives saying somebody else has an earlier trademark and wants you to stop using the name. By then, the legal costs may actually be the least of your problems. Think about the commercial cost of changing the name of a business that your customers already recognise. You're going to have to think about things like a new website, new domain names, new packaging, new signage, new email addresses, new marketing collateral, potentially rebuilding years of brand recognition. That's why we always encourage founders to think about intellectual property much earlier in their journey than they often do. And there's another point where this suddenly becomes very relevant: investment and selling your business. If you're raising money, an investor is going to want to understand what intellectual property the company actually owns. If you're selling the business, the buyer is going to investigate it during due diligence. They may ask, who owns the underlying brand? Is the trademark fully and properly registered? Where is it registered? What exactly does the registration cover? Are there any challenges to that registration? Has anybody alleged infringement at any point? Could another company potentially stop this business using the name after we've bought it over? Suddenly something that felt like a fairly boring administrative job when you started the company can have a very real impact on the value and investability of the business. So if you're at the beginning of the founder journey, or you're launching a significant new product or brand within an existing business, don't just ask whether the company name is available right now on Companies House. Think about what you're actually going to sell. Think about the markets you're going to be operating in, and think about where you might expand in the next few years. Carry out proper searches and think about protecting the brand before you invest heavily in building value around it. Because the fascinating thing about the Lady Gaga case isn't simply that a celebrity won a trademark lawsuit, it's that Lost had what on the surface sounds like an incredibly strong case. They had used Mayhem for decades. They had registered it the way you're supposed to. They had registered it for clothing. Lady Gaga started selling Mayhem clothing. They sued for at least $100 million and they still lost. Trademark protection can be incredibly powerful, but it's much more nuanced than simply asking who registered the word first. And for founders, the lesson here is really simple. Protect the things you're building before they become incredibly valuable, and make sure you understand actually what that protection does and doesn't give you.